When the 13 American colonies rose in rebellion against the British Crown in 1776, they assumed for the new nation a new name, the United States of America. 11 years later, in 1787, representatives of the 13 states again assembled in Independence Hall in Philadelphia. This time, they proposed to forge for themselves and for their fellow citizens a new national charter, a constitution that would become the basic law of their country. Delegates to this constitutional convention met first on May 14, 1787. Notably absent was Thomas Jefferson, serving as ambassador to France, but he will make vital contributions to the convention nonetheless. 6 of the delegates took the lead in hammering out the provisions of this proposed constitution. These 6 men are now coming into the chamber for discussions as to the protection of inventions and literary material. These discussions went on from August 18th to September 5th, 1787. On September 17th, 1787, just 12 days after the conclusion of this scene, the Constitution was adopted and signed by the delegates. The first 2 delegates are Virginians, James Madison and Edmund Randolph. Following them are Charles Pinckney of South Carolina, Dr. Benjamin Franklin of Pennsylvania, and Alexander Hamilton of New York. Finally, to call the meeting to order comes the President of the Convention, General George Washington, also of Virginia.
Gentlemen, be seated. Our original objective in convening today was to fashion a provision for our new Constitution, one which would grant some measure of protection, that is, exclusive protection, for authors in their writings and for inventors in their novel ideas and craftsmanship. However, I understand there is a contrary point of view expressed by our distinguished colleague, Dr. Franklin, who has now publicly disclaimed any such award for 2 of his most important inventions.
I believe, Mr. President, you are referring to the awards or grants which the governor of Pennsylvania, my home state, offered in recognition of my inventions, which have familiarly become known as the Franklin stove and daylight saving time.
That's correct, Dr. Franklin, but I'm sure that we would all agree that you would have been deserving of those rewards.
Sir, I am deeply honored by your offer. However, I cannot accept because I have long held a view that if I conceived a unique invention, I would bestow it upon the public. I would not look for any reward. I would only expect the joy of it and the honor of it. To me, gentlemen, it is a duty, and I look upon it as an example of noblesse oblige.
Well, perhaps there's another point of view. Mr. Madison?
Yes, of course. Dr. Franklin, that is a typical contribution which you have made to the welfare of so many people. If I may say so, sir, it is statesmanship in its highest form.
Mr. President.
Yes, Mr. Randolph.
That may be, but I think it depends upon one's conception of what is statesmanship. Are there not other factors comprising the virtue of statesmanship? What about good citizenship? Doesn't good citizenship require that a man seek a just reward for his efforts, be he farmer, tradesman, author, inventor, so that he can support his family, his church, and his country?
Mr. President.
Yes, Mr. Pinckney.
Yes, that is correct. Gentlemen, in our concern for the benefits to the country as a whole, we cannot overlook the rights, the welfare of individuals. Fault is the efforts of individuals, properly directed and protected, which make for the well-being of a country. Indeed, wasn't Mr. Jefferson thinking of this very principle when he drafted the Declaration of Independence?
Exactly. One may express a wish or a creed for man to follow, but can one actually legislate against human nature? Are we to assert in our Constitution and in the laws to be enacted under it that a man may not keep his invention or his literary ideas to himself?
Well, that would be neither logical nor practical. In the first place, such a law would be almost impossible to enforce. And we cannot forget the promise of the Bible, that all men are entitled to the fruits of their own vineyard.
Mr. President, if I may.
Yes, Mr.
Yes, Randolph, you are absolutely right. We certainly cannot mandate humans to deny themselves a reward for their efforts. Why? Why, such a law could not even be passed, let alone be enforced. Rather, we must induce inventors voluntarily to make them public.
By induced, you mean a reward for doing so?
Exactly.
A cash reward, a bounty of some sort.
Not necessarily a cash reward, Mr. Madison. Indeed, a better inducement would be to give an author or an inventor some form of protection against the unlawful duplication of his novel conception. He should be assured that, at least for a limited period of time, that he would have the right and the opportunity to capitalize on his invention or on his literary work first, before others would be permitted to use it for their own benefit, financially or otherwise.
But is this wise? Just as we enjoy the great advantages from the inventions of others, we should be glad for the opportunity to extend our innovations for the sake of our fellow man.
Well said, Dr. Franklin. I personally share your philosophy in principle, but let us face facts as they really are. You and I are fortunate enough to be men of considerable means. We really have no need for any additional wealth, except possibly for the sport of attaining it. We can well afford to give to our countrymen, even to the world, any ideas, suggestions, or inventions we may have without seeking anything in return.
But that is such a narrow view, sir. Every provision of our Constitution should be for the benefit of all men, not just for those who possess considerable wealth. And I think Mr. Jefferson had this in mind when he said that all men are born equal and endowed with inalienable rights.
No doubt about it, Mr. Madison, but facing the facts of life such as they really are, I have another observation to make. Speaking less altruistically and noting what Dr. Franklin has said, we stand to enjoy the benefits flowing from the inventions and writings of all others. And if we don't exact a toll from people for disclosing our novel ideas to them, we won't have to pay other people for the use of their inventions.
But that's such a narrow view, sir.
Well, of course it is. And certainly the Constitution must be for the benefit of all men. That is why I'm opposed to any provision that would stand in the way of the very concept and thrust of the law that we have in mind. Namely, to induce our people to exert their time, their energy, and even their wealth in the making and public disclosure of their new inventions.
Mr. President, if I may.
Yes, Mr.
It certainly would defeat that objective. Gentlemen, why should people spend their energies and their money in developing their novel ideas if everybody would be free to copy them the first time they see them? If our aim is to fulfill our stated objective, why then, gentlemen, we must protect the novel creations of such men.
I am beginning to see the logic of your reasoning, and I think it has merit. Does any one of you gentlemen have a proposal which would accomplish this?
I do. Based on what I've heard stated here today, I propose that we enact a body of laws that would constitute a form of patent system and a form of copyright system. I recall reading that numerous forms of such laws have been employed in European countries for some 200 years or more. As a matter of interest, perhaps, the Republic of Sabari in southern Italy enacted a law in 600 BC that provided for certain inventors the exclusive use of their invention for a period of 1 year, the purpose being to encourage others in the development of simple inventions.
Hold on, I must object. We should not copy the systems of other countries merely because they've been in existence for 2 centuries or more. No, this subject requires far more analysis and discussion. Mr. Hamilton, I propose these questions be considered. Is there a genuine need for such protection of the individual? And if so, what shall the nature of that protection be?
Mr. Randolph, of course there's a need for such protection, and we must avoid the sad results of the human greed so evident in our mother countries. Dr. Franklin, surely you have some ideas on this subject?
I do, sir, but with some reservations, so I am not yet ready to agree with either of you, gentlemen.
Well, now, surely, Dr. Franklin, you have read Mr. Jefferson's dispatches to us, deploring the injustices done to writers and inventors in other countries. He complains that no sooner does a man disclose a novel idea or invention than others rush to copy it and exploit it, without permission to do so, and generally without offering to pay for it.
I must admit, Mr. Hamilton, that you make a rather convincing case for a system of granting rewards to inventors voluntarily to disclose their inventions rather than keep them secret. But should this not also apply to authors? If authors wish to publish their works, they assume the risk of having all their efforts copied and widely printed without receiving any remuneration at all. Now, do you have some way of a proposal that would correct this situation?
Dr. Franklin, perhaps if I gave a brief history of copyright law as it appeared in England and in many of the states in our own country, perhaps we would all have a better idea of why we need federal copyright protection. You see, copyright was granted by common law in England, and it wasn't until the English Statute of Anne in 1710 that authors and publishers had to give their consent to use their writings. Now the law, as it went along, changed, and soon the credit was given where it belonged with the authors, thereby breaking this legal monopoly of the printers. Now, although this change in practice and procedure was well known here in our country, the Articles of Confederation, nevertheless, did not contain a copyright clause. Rather, they relied on a recommendation of the Continental Congress that each state provide their own copyright protection.
But what did the states do?
Well, the states, all the states except Delaware, passed some sort of copyright law, but you see, they were all with different provisions. And since they're effectual only in their own jurisdiction, they're largely ineffectual. Gentlemen, what we need is federal copyright protection, which gives credit to the author and not to the secondary actors such as the publishers and the printers.
I understand, Mr. Madison, that you and Mr. Pinckney have contrived a clause which, if incorporated into the new proposed Constitution, would ensure the protection of authors and inventors. And may we know what you have in mind, gentlemen?
Yes, Dr. Franklin. Mr. Madison and I have developed the specific language of a proposal as you gentlemen asked us to do.
Yes, we propose a clause, number 8 of Article 1, that would read as follows. The Congress shall have the power to protect the rights of authors and inventors in their respective writings and discoveries.
The language sounds all right to me. It should be sufficient to grant to authors and inventors the right to exclude and prevent others from copying or using their creations without their expressed permission.
I agree. But, gentlemen, I think it would also be well to recite the concept so often expressed by Mr. Jefferson, that the power given to Congress was for the purpose of promoting the progress of the country. Such progress, gentlemen, can only be achieved by protecting an individual, or a group of individuals, or a company. Only then can society, our nation, benefit as a whole.
Ah, now I see things in a different light. I like Mr. Jefferson's ideas about promoting the welfare of our country, and I think we should protect authors and inventors. But I would add one other bit. We should limit their rights to their inventions and to their works as authors. And we must do this, gentlemen, if we are to avoid the abuses of monopoly, which is an evil that could devastate all the good intentions of this assembly.
Yes, Dr. Franklin, I would recommend that the proposed clause specify that the right to be given to inventors and authors be made exclusive. In agreement, however, gentlemen, I must go along with Dr. Franklin's admonition that such right be for a limited period of time.
Then, gentlemen, let us put it this way. Congress shall have the power to promote the progress of the country by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries.
Fine, but let us make it even more specific. How about this? Congress shall have the power to promote the progress of science and the useful arts by securing for a limited period of time to authors and inventors the exclusive right to their respective writings and discoveries.
I think that will do it. Do all of you agree?
Yes, I do.
I do too. I think the language is clear and should be readily capable of interpretation from the legal standpoint, and it probably will be the legal basis for important foundations to the commerce and industry of our nation.
Thank you, Mr. Randolph. Gentlemen, I think we may have reached an accord on the issue before us. We'll put it to a vote by roll call, if you please. Dr. Franklin?
Aye.
Mr. Hamilton? Aye. Mr. Madison?
Aye.
Mr. Pinckney?
Aye.
Mr. Randolph?
Aye. And may I make a comment, sir? I believe that the provision we have approved here today will be adopted without hesitation by the representatives of all of the 13 states, and in time will prove to be one of the most important clauses in our Constitution.
Thank you, Mr. Randolph. Gentlemen, the vote is unanimous.
Hear, hear.
There is, of course, no need for me to vote, but I can assure you that had there been, I would have been in favor. We stand adjourned.
On March 4th, 1789, the government of the United States of America began functioning under the new Constitution, which had been adopted in 1787. From 1790 to 1800, the Congress met in Congress Hall in Philadelphia. On occasion, the Congress met in New York City. On one such occasion, on January 8, 1790, George Washington, the first president of the new nation, addressing the second session of the first Congress, declared,
Honorable members of Congress, you have before you Article 1, Section 8, Clause 8 of the Constitution. This was enacted by the Constitutional Convention, which saw in it a means of satisfying a vital need to stimulate our economy by protecting for limited times the works of authors and inventors. There now remains a duty upon you to enact the enabling legislation which will form the basis for the practices and procedures.
On February 16, 1790, on behalf of a commission consisting of Adenis Burke of South Carolina, Benjamin Huntington of Connecticut, and Lambert Cadwallader of New Jersey, the chairman, Mr. Burke, presented to the Congress a patent bill which was the subject of much discussion. Thomas Jefferson, having returned from France and now Secretary of State, also took part in the discussion. We now look in on the final debate before members of both houses present in joint session.
Mr. President, Mr. Jefferson, Dr. Franklin, my distinguished colleagues, I have brought before you a bill which, when enacted, will provide for our first patent law. I am proud to point out that this will be the first time in history that an inventor will have the intrinsic right to profit from his inventions. No longer will an inventor be dependent upon the prerogative of a monarch or upon an act of legislature for the benefit of his invention, for he will have the right to his invention as established by law.
Does the bill clearly define what ideas and devices are patentable?
It does indeed, sir. We would define a United States patent as any art, manufacture, engine, machine, or device, or any improvement thereon not known or used. And we would require that to apply for a United States patent, a drawing and specification, and if possible, a model must accompany the application.
Gentlemen, I must apologize for a memory that no longer functions as in the past. But I seem to recall that when we approved the article of the Constitution to which Mr. Burke referred, we emphasized that any acts to be passed by the Congress must provide that a patent or a copyright be for a limited time only. Does your bill provide for such a contingency?
Yes, it does, sir. We would recommend a period not to exceed 14 years.
Can a patent be issued for a lesser period of time, and who will determine this?
Well, the actual period will be determined by a board whose members we recommend should be the Secretary of State, the Secretary of War, and the Attorney General. This board, incidentally, will only issue a patent if they deem the discovery or invention sufficiently useful and important.
But will there be provision for appeals from the board?
No, sir. We feel that the decision of the board to grant or refuse patents should be absolute. Later, perhaps, consideration should be given to the creation of an appeals board or perhaps even appeals to the court.
Do you have any recommendation as to which branch of our government should administer our patent laws?
Yes, sir. We recommend that it should be administered by our State Department.
Gentlemen, what about fees? I trust that you are not proposing and enlarge fees which would discourage people from applying for a patent.
No, sir. The fees will be modest. We believe that the filing fee for the filing and issuance of a patent should be between $4 and $5. This would allow to defray some of the cost of the filing of the fee of the application, discourage whimsical applications, and yet not be so high as to discourage people from filing applications with the patent board.
I think that sounds reasonable enough.
Yes, gentlemen, and I agree with the language as proposed by Messrs. Burke and Jefferson.
And so the Congress agreed to all of these proposals. On April 10, 1790, President Washington signed the first patent bill into law. The first board consisted of Thomas Jefferson, the Secretary of State, Henry Knox, the Secretary of War, and Edmund Randolph, the Attorney General. It styled itself the Patent Board, the Patent Commission, or the Commissioners for the Promotion of Useful Arts. In actual practice, as Secretary of State, Thomas Jefferson was, in effect, the first administrator of the American patent system. Jefferson, noted for his opposition to monopolies, nonetheless became a firm believer in the value of limited monopolies for authors and inventors. He later wrote,
Certainly an inventor ought to be allowed the right to the benefit of his invention for some certain time. No one wishes more than I do that ingenuity should receive liberal encouragement. In the arts, especially the mechanical arts, many useful inventions and improvements will be made in consequence of the right granting exclusive use for a patent for 14 years.
Jefferson was not only the first supervisor of the patent office, he became the moving spirit behind the board, which decided whether patents were to be granted. He made a personal examination of all the applications that came before the board. The first patent issued by the board was to Samuel Hopkins of Philadelphia on July 31st, 1790, for an improvement in the making of potash by a new apparatus and process. It was signed by George Washington, the President of the United States, and countersigned by Secretary of State Thomas Jefferson and Attorney General Edmund Randolph. In due course, and in a similar vein, the Congress was presented with a bill calling for national uniform copyright protection for school textbooks, maps, charts, and books on science, agriculture, and medicine. Congress approved the bill with very little debate, and President Washington signed it into law on May 31st, 1790. As an interesting sidelight, the President was heard to say at the conclusion of the signing ceremony,
When I think back over these past few weeks, when only a handful of our leading patriots gathered together and in just a few short meetings were able to devise the constitutional provision and all of the enabling legislation for our new and important patent and copyright acts, I marvel at the fact that not one of them utilized so much as a single administrative assistant. Surely, that's a shining example of administrative efficiency which will be followed by lawmakers for centuries to come.